Hello, everyone. Welcome, welcome, welcome. We are so glad to have all of you here because today we are going to have a thrilling, if you love taxes and you want to know more about trusts, you are in the right place today. I'd like to present Ruth Benjamin, who is an expert in this area, and she is going to give you a little background on herself and teach us a little bit about what's going on with taxes and trusts. So thank you very much for being here today, Ruth. We really, really appreciate you coming and educating us because I know you are the wizard.
Well, thank you, Peggy. We do have quite a few different strategies, and the trust product is what I call one of the ultimate tools for taxes.
Great.
So you ready to get started?
We're ready. It's all yours.
Okay. I just want to make sure we were ready to go here. All right, so my name is Ruth Benjamin, and I'm going to be talking about, it's a trust structure that I'm going to be talking about today. We call it the doing well by doing good strategy. This strategy involves trust and private family foundation. So it has asset protection and tax mitigation. So again, my name is Ruth Benjamin. I am a capital gains tax strategist. I spent 22 years of my career as president of 2 different title company owned accommodator companies, but I'm currently the customer success manager at National 1031 Exchange Services. And I've spent close to the last decade working with other strategies when 1031 was not the best fit. So we do have our disclaimer, okay? We are not providing or attempting to provide tax or legal advice by making this overview available to you, nor does the overview itself contain sufficient information to constitute tax or legal advice. So what we're talking about today is, I'm sure you guys have heard, well, Nelson Rockefeller says it the best: the secret to success is to own nothing but control everything. Well, the main problems in today's society is capital gains taxes, right? A lot of people don't want to sell their properties because they don't want to pay the capital gains taxes. Or if you have people that are doing 1031 exchanges, they're very stressful because of the 45-day and 180-day time period. And 40 to 60% of exchanges will fail. For one reason or another. Maybe, somebody identifies a property and the seller doesn't want to fix the foundation problem and it fails. Okay, so we have solutions for that. Plus, there are some proposals out there where they're trying to limit the amount that you can defer on capital gains up to $500,000 per person, okay, $1 million per couple. And so that is a big stressful point. Also, when you put money into investments and you get all this nice return, that's wonderful, right? But what happens? That return gets lessened because now you have to pay the taxes on the amount of money that you made on your investment. So we search the Tax Foundation website and get updates for proposed laws. And the proposals are to raise the top capital gains bracket to 28% plus 39.6% of any gains over $1 million. They want to eliminate step up in basis. And then, of course, back to the 1031 to cap the amount that you can defer for $500,000 a year, and then reduce the the tax exemption from 11.58 million to 3.5. And in 2026, with the sunset clause, it's expected to drop to about $6 million per person. Also, most people don't have solid asset protection. Corporations, S-corps, and LLCs don't protect you as well as you think. It's easy to pierce the corporate veil on these tightly held entities. So you are operating under your alter ego. The courts claim that you are controlling, so you're the only owner of these entities. So it's a very winnable argument when somebody's trying to sue you to convince the judge that your entity and yourself are one and the same. If you don't have 35 members in your LLC, you're going to run into problems. So these entities are getting pierced. They're piercing the corporate veil. So roughly 50% of the entities can be pierced because they are not operating their businesses properly when it comes to the records, the meetings, and the minutes. So if those records are pulled into court, you're going to run into a problem. So they're going to pierce the corporate veils. So once you have your trust set up, it can be done, the minutes and all that can be done with no more meetings, no more corporate minutes, and sometimes the corporations are not needed. So 39.34% of the state courts are piercing these entities, 41.42% federal courts are piercing the entities, so it's not a preferable way to hold properties. Now let's talk about insurance. Insurance is not the solution. An umbrella insurance policy often do not cover punitive damages or gross negligence. However, you may still want to have an umbrella policy depending on your circumstances. So we never advise to get rid of any insurance. It's just sometimes not the great protection that you want it to be. Then problem number 8 is filial responsibilities. Many states have filial responsibility statutes allowing long-term care facilities to seize the assets of adult children to cover unpaid bills of their parents. So take a look and see. California is on this list, and Florida is not on the list. So if you know everybody that is in one of these states and they have a parent that's going into a home, you need to protect yourself. So the solution is our tax deferral and asset protection trust. We call it a family holdings trust, but we pair it with a private family foundation. That's how you get asset protection and tax mitigation. So the first things to know, this trust is a non-grantor, irrevocable, complex, discretionary spendthrift trust. It is not self-settled. It's a dynasty type of trust. So these trusts offer the best asset protection in the United States without going offshore. So without saying all those components of the trust, we call it a family holdings trust. And then if people have businesses, we can create a business trust that helps with tax mitigation for the business trust also. So the family holdings trust is a contract between the grantor who creates the trust and the trustee who will manage, invest, and maintain the assets owned by the trust for the ultimate benefit of the beneficiaries. So the trust protector, whose main job is protecting the interest of the beneficiaries. So the trust protector's role is to act in a way that's comparable to the board of directors in a public company. It is the ultimate authority with respect to the operation of the business after the grantor's tasks have been completed. So our clients are almost always named as the trust protector to ensure that ultimately they have complete and total control over the trust assets and decisions made with respect to the trustee and the beneficiaries. So among other powers, the trust protector and only the trust protector is authorized by specific provisions included in the written expression of the contract between the grantor and the trustee called the trust instrument. So the trust protector can add and or remove beneficiaries at any time from time to time in the trust. They can remove a trustee and or appoint a new trustee or new co-trustee, and they can name or replace a successor trustee and a successor trust protector, and they can modify the trust document at any time. So step 1 is to create the trust. So an independent third-party grantor creates the trust to ensure that the trust will be classified as a non-grantor trust and not one that is self-settled according to the IRS. The person who creates the trust, the grantor, can be a family friend, a business associate, etc. It can be parents. But if you prefer that no one know or made aware that the trust is being created, we can help you locate somebody to act as the grantor. Okay, so in other words, the grantor of your trust can be any competent adult who will never be a trustee or a beneficiary to the trust. So the grantor will apply for the EIN number. They order the trust instrument from the attorneys who prepare it, and they write a check to the trust for a nominal sum to initially fund the trust. So when the trust instrument, the contract, is received from the attorneys, the grantor that set up the trust will sign the trust. And what they're signing is going to include provisions turning over the complete control of the trust from that moment onward to the trust protector. So that's the client, the owner, right? And the trustee. The provision stating that the grantor is irrevocably forfeiting any right he or she may have had to change any terms of the trust. The grantor cannot exercise any control over the trust assets. The grantor cannot demand the return of the money he or she gifted to the trust to fund that trust. So the grantor will go away forever with respect to anything having to do with the trust itself or the properties that it owns. So by following the steps outlined in the previous slide, we can ensure that there will never be an instant in time during which your family's assets will be under the control of the independent third-party grantor. None of your family's assets will be transferred to the trust until after each and every right, power, privilege, and authority the independent third-party grantor once held with respect to the terms of the trust and to its assets has been permanently and irrevocably forfeited by that grantor. That grantor cannot even go back and ask for the money that it took to fund that trust. So step 2. Now we're going to transfer the assets to the trust. So neither you nor anyone who might ever be a trust protector, a trustee, a co-trustee, or the beneficiary of your trust should ever gift. Oh, something exited. Something's
Weird.
Did she drop off?
I think she did.
Yeah, Ethan's
That's
unmuted
weird.
again.
Ethan, what's going on with you? I can't get him to mute. There he is. Oh, well, this is a first, y'all. A first. Well, welcome everyone. Who we didn't say hi to before.
I can continue the lecture if you'd like, Peggy.
Okay. I
do want to circle back on something she said that I don't think most people realize, and she did hit a point that was probably way under the radar.
Okay.
There is a significant, she said 50%. I think that's probably maybe a little low. The LLCs that people do, they don't do the formalities and they're just opening themselves up for a veil piercing problem later on.
And she's going to tell us how to avoid that altogether with this, what she's talking about with these trusts, correct?
Well, I think what I would say is it's a way of protecting yourself. If some reason it fails, it's like another layer of protection is what I would say.
Okay, that's great. So here she comes back. All right, good.
okay. All right. I don't know what happened. Somebody actually, my computer started working and it just disconnected. So I apologize about that.
That's okay. All right. It's a burst.
That was strange. It completely logged out of my computer all the way. So let me share my screen again and make sure we're good here. All right, let's see if we could get this moved over. Hold on, I got to stop sharing just real quick and move this over. All right, you guys, I'm going to be looking one way and presenting another way because this, the way that my computer came back up. So apologize for that. All right. So Instead of gifting assets to the trust, you will sell them to the trust. So the trust pays for the assets. It purchases them from you and perhaps from other family members by issuing a demand note. A demand note is a legal obligation of the trust. Interest is included as required by the applicable federal rate published from month to month by the IRS. Payments are only made upon the demand of the holder of the note. There are no monthly payment obligations. So the demand note is non-transferable, so it cannot be reached by any creditors. So step 3, living within the trust from day to day. So once your assets have been conveyed to the trust, sign your name on your trust checking account as you, trustee, when you're acting in your official capacity as the trustee. So pay for functionally everything you buy with a debit card tied to the trust checking account, even for food, fashion, and fun items. We will discuss how valid trust expenses and demand note principal payments keep the payments from being taxed to a beneficiary or trustee. Keep your receipts for everything the trust pays for. You would do this for any business you operate to justify information reported on tax returns and financial statements. Okay. So Peggy, I got a note on my computer that says that somebody's requesting remote control of my screen. So I think before I hit approve, and that's how I disappeared. Do I hit decline this time?
Yes, no one
Okay.
should be getting control of your computer.
Because I approved last time and that's what it took off. So, all right.
I don't know who would be doing that.
Does it show the name of the person who's requesting control?
No.
Yeah,
So we
that's
can-
scary.
There was
Yeah,
a DWD on earlier.
It shows,
Oh.
it will show the name.
Yeah, it just said that somebody was requesting. So when I was presenting last time, I figured it was somebody from your office. So I hit approve and that's how everything disappeared.
No,
So I
no,
declined
no.
it this time. So that was probably what happened the last time. All right, so now we have to deal with record keeping, right? If you keep your tax records in Excel worksheets, QuickBooks, Quicken, or similar files, keep doing what you're doing, okay? But if you're not sure how to do that, we can help with the bookkeeping. And if you currently keep your records in a shoebox, you might need to do things in a different way. But again, we can show you how to do that. So now we're going to talk about valid trust expenses and demand notes. So pursuant to the applicable federal and state income tax codes and the principles and procedures established in GAAP and or trust accounting methodologies, expenses paid by the trust for the care and maintenance of trust. Okay, so expenses paid by the trust for the care and maintenance of trust-owned assets will be recorded in the trust financial statement as valid trust expenses. So expenses paid by the trust on behalf of the trustee or the beneficiaries will be booked as valid trust expenses if they legitimately are, or posted as principal interest payments per the balances owed to the trustees and or beneficiaries who hold the demand notes from the sale of the assets to the trust. Only the interest portion of the demand note payments will be taxed to the holder of those notes. So your CPA, enrolled agent, bookkeeper, or other paid tax professional will prepare the trust's federal form 1041, and if required, its state income tax return annually. They will also update the trust financial statements at least annually. The tax returns in those financial statements will be given to lenders when requested for loans the trust applies for to purchase any real estate, vehicles, or anything else the trust purchases, except assets it buys from you or the family members, which are paid for with demand notes, and assets the trust purchases for cash. So you, as trustee, you can sell assets owned by the trust, you can buy assets in the name of the trust, you can borrow money in the name of the trust, you can lease vehicles or equipment, lease property to tenants of trust-owned assets, buy, sell, trade, EFTs, public securities, cryptocurrencies, interests in syndications, etc. You can sponsor private placement offerings using available state exemptions from registrations as a security and or SEC Reg D, and virtually anything else you want to do as an individual. So you as the trustee can also use optional intellectual property provisions that can be added to the text of your family holdings trust to enable it to purchase your IP, your copyrights, trademarks, software that you've developed, manuals you've developed and used in the operation of your business. You can sell it to the trust in order to monetize it and provide even more protection than trademarks or copyrights alone can offer. You can receive distributions from a separate business trust created to be and or become the owner operator of an unlimited number of autonomous companies without having to pay any state regulation fees or tax prep fees for each company as required if you're using LLCs as your main form of protection. So you enter into transactions such as the following in the name of the trust to get long-term, even permanent deferral or elimination of capital gains taxes. So sale of companies, real estate, or other appreciated assets, but not securities issued by public companies. You own now to the trust using 25 or 30-year installment-only notes per IRC Section 453. Now, it requires post-sale hold by the trust for 2 years and 1 day. So you can 1031 exchanges has a 1-year hold, but this is where you're not using the 1031, you're using the trust, okay? You can do Delaware statutory trust. You can have angel or venture capital investments in Section 1202 small business stock. So if a charitable contribution is made after the close of such taxable year and on or before the last day of the year following the close of such taxable year, then the trustee or administrator may elect to treat such contribution as paid during the taxable year. So when using the foundation, you can put money into your foundation. You don't have to do it by the end of the year. You can make the donation by the end of the following year to get your tax deduction, okay? So any part of gross income of an estate or trust, which pursuant to the terms of the governing instrument is paid during the taxable year for a purpose specified in Section 170C, shall be allowed as a deduction to such estate or trust in lieu of the limited charitable contribution deduction authorized by 170A. So in determining whether an amount is paid for the purpose specified in Section 170C, the provisions of Section 170C2A shall not be taken into account. Thus, an amount paid to a corporation, trust, or community chest, fund, or foundation shall be considered paid for a purpose specified in Section 170C, even though the recipient is not created or organized in the United States or any state in possession of the United States.
Can you put that in English?
Yes. So let's go through here.
I mean, you're giving all this tax code stuff, but I'm not quite following.
And I think we got jumbled with the stuff that's happening. So what's going on here? If you sell a property to your trust 2 years and a day before the trust sells it, then you're selling it on an installment contract, interest only for 30 years. So all of the gain is tied up into that contract.
So if you own the property for 20 or 30 years, but it hasn't been in the trust, it has to be in the trust for 2.5 years or 2 years before it can be sold.
Yep, 2 years and a day. Okay.
Otherwise, it pays capital gain.
Yes.
Right. Okay. So in order to mitigate the tax, you sell your property to your trust at fair market value on an installment contract, interest only. So now the trust owns the property. Then the trust sells the property after 2 years and a day, anytime after 2 years and a day. Okay, you don't sell it before 2 years and a day, or the installment contract becomes invalid. Okay, so anytime after 2 years and a day, the trust can sell the property to a true buyer. Okay, a third party buyer. Now the third party buyer buys the property at the current value. So the non-grantor trust that has its own tax ID number now only pays capital gains taxes on the 2 years and the day that it owned the property. So you took all that gain and tied it up into the installment sale. Now it only pays 2 years and a day of the gain. So let's say the gain is $100,000. The private family foundation that we set up for you, along with the trust, if it's $100,000 of gain, you take that $100,000, put it into your private foundation, and now you've eliminated the tax bill. On the amount to the foundation is elimination of tax. The amount of the installment sale contract that tied up the gain from the day you bought it till 2023 when you put it in the trust, that's tax deferred for 30 years.
Got it. Thank you very much.
Okay, so let's get past this here. So the first rule of tax planning is don't lose your assets. All the tax planning tools in the world will be useless to you if someone else uses a court order to take your money or your assets. So remember, LLCs, if you're using LLCs and you don't have 35 members in it, it's a coin flip. Okay, with the judge, if they're going to allow the person who's suing you to access all of your assets. Okay, and that's single member LLCs, all types of LLCs, unless you have 35 members. All right, so the asset protection isn't about making you suit proof. Okay, people can still sue you, but what it does is it allows them, if they do get a judgment against you, the trust agreement is a contract between the grantor and the trustee. And this contract, this trust agreement says you cannot give any money to anybody that's not a beneficiary. So if somebody sues you because you bumped into them in their car, you know, when you're talking on the phone or something, you bump into them, then they sue you and win, and they want you to provide for them for the rest of their lives because you hurt their elbow, right? It's millions of dollars. And you're like, no, I'm not going to do that. But let's say that you feel bad that you bumped into the person, they missed a couple days of work and they hurt their elbow. Well, what you can do with this trust is you could go to your trust book, you can write their name in as a beneficiary, write them a check for a few $1,000s that you feel bad of hurting them, and then you go right back to your trust book and you remove them. Okay, so you are able to work that way with the trust. Okay, so that's just kind of what I just covered. But remember, you just want to make sure that with the foundation I talked to you about, you don't want to have any self-dealing rules. So the rules of the foundation are whatever the assets are of the foundation. So let's go back to that $100,000 gain. You put the $100,000 into your foundation. Now your foundation has to give 5% of its assets to a true charity. So Wounded Warriors, St. Jude, your church, any type of 501c3 charity, 5% has to go to that charity. So now you have $95,000 sitting in your trust checking account. That $95,000 remaining, in my example of the $100,000, can be used to invest with you for real estate. Let's say you want to go buy some rental real estate. You don't want to buy a primary residence because anybody in your lineage cannot benefit from the foundation's money. It can benefit from trust money, but not the foundation's money. The foundation can partner with you to buy investment real estate. So let's say you need a 30% down payment. The foundation can come in with the cash that normally you would have given to the IRS, and they own 30% of that property. You can own the remaining 70%. And so rental income on that property, 30% goes to the foundation, 70% goes to you. When that property sells, then 30% of that sale goes to the foundation and you keep the rest of it. So you can partner using that foundation's money. The other thing I like about the foundation is, let's say a house burned down in your neighborhood and you feel bad for the family. They need some blankets and some coats and maybe some water. So you go to get your debit card from your foundation's checking account and you can go buy those items for that family. Just because they don't have to be a true 501c3 in order for you to help. Okay, so the foundation is a great tool, especially for people that already love giving. It just makes it even better because when you give from the non-grantor trust to the private foundation, you get unlimited deductions for that donation. Us as individuals or companies, when we give to our churches or the charities that we want to help out, we only get 20 to 60% deduction on our donation. So this is a great way to help for people that are already giving. All right, so a reminder that this family holdings trust is a dynasty trust, meaning that it's designed to provide benefits to your family for generations. The trust needs to be renewed every 20 years by the trust protector. Now, there is no cost involved to renew the trust and nothing to file with the copyright holder or any state or federal government, nor no annual reports to be filed with the Secretary of State or the Franchise Tax Board to keep this in good standing. So in most cases, you won't need any LLCs or corporations that you currently have once your assets and companies have been transferred to the trust. So in Wyoming, an LLC will cost you $52 a year, and in California, it will be $80 a year, okay? When your properties are sitting in your trust, you can still do 1031 exchanges if you want to. Tax deferred cash out is another strategy that we use to defer your tax bill for 30 years and defer the taxes for 30 years and get your cash within 5 days. It can also do Delaware statutory trust, opportunity zones, and Section 1202 small business stock. So when you're working with the trust, we will send you some information on it. Set up a time with me or anybody with financial tax strategies. We would send you an intake form if you want to get more details on it. But the key is for most people, if they want to sell properties, get them in the trust now for the asset protection. 2 years in a day, they could sell the properties and defer most of the gains and eliminate some of the gains. And we like to use life insurance for when the tax bill comes up 30 years from now. A lot of people are buying life insurance products. They don't have to be on themselves. They could be on a family member or a child or a grandchild to make the rates great. But that life insurance policy down the road will actually pay the capital gains tax. So here's my contact information, and I am ready to answer any questions that you guys have.
Okay, great. Yeah, and you can all contact us if you'd like, and we'll do the introduction. That would be great. Well, I do have a couple questions.
Okay.
If nobody else has any first, because David, go David.
Well, thank you, Peggy. I will go. Thank you so much. I do have a couple of questions in reference to 1031 exchange. Let's say if you have a property and you sold it, it's sizable, and you have some funds in 1031 exchange, and you wanted to utilize it for another property or this. I'm just curious how that would work with this.
Mm-hmm. With the 1031 exchange, if you've already closed on your property and the money's sitting with the accommodator, the trust structure is not going to help you at this point. But we do have tax deferred cash out if the accommodator will cooperate and you're not able to locate a replacement property. We can move you to the strategy that allows you to defer the tax for 30 years and receive your cash. Now that money needs to be used for business or investment purposes, but if you have other investment properties that have mortgages, you could use the funds from that tax deferred cash out and pay off the other mortgages, and then your rental income is all yours. You can spend it however you want.
So 1031, they give you so much time to identify and locate.
Mm-hmm.
So if it goes beyond that, if it's within this trust holding, does that change, or how does that work?
If you are, David, can you tell me, have you already closed and the accommodator's holding your money?
No, I have not, but I'm looking to do so.
Okay. So I am an accommodator. Well, I work with National 1031 Exchange, and we are an accommodator that will cooperate. I like to call it Plan B. So if you're in the middle of a 1031 exchange and you're not able to locate a property anytime within that 180-day time period, as long as the exchange period's valid, we can move you at any time to tax deferred cash out. And then it converts to you receiving your cash and deferring the tax bill for 30 years.
What happens if he were to put it into a trust?
The
How would
you
that
would
work for the 1031?
So if you have properties in the trust, then it depends on if you're trying to sell it now. Remember, you need 2 years and a day. So if you want to put the property, you put the property in the trust has to hold it 2 years and a day. And if you want to, you can do a 1031 exchange in the trust. But if you want to sell before 2 years and a day, then we use tax deferred cash out, or we have charitable holdings. We have different solutions depending on every situation.
Thank you.
Okay, thank
Any
you.
other questions, David?
Yeah, I do. In reference to California, if you're going to exit out of your LLC and get into, like you said, maybe some sort of other holding trust, or if you change that, isn't California going to follow you? They're going to want their money still and so forth once you even change that, your structure?
Well, California allows you to have estate planning. So when we transfer the property in California, you know, they can reassess your property taxes. Okay. But the way that we've been getting around that is there's a P Corp that has to be filed every time you transfer title in California. Well, if you don't file the P Corp, it simply costs you $20. So right now what they're doing is just avoiding the P Corp. What I like to do, the P Corp is preliminary change of ownership form. What I like to do is have somebody else besides yourself be the trustee at the time you transfer properties and sell properties to the trust. And then you become a beneficiary, because on that P Corp, it states that if the beneficial ownership hasn't changed, they won't change the property taxes. You
Right.
see what I mean? So it's just each person we have to talk to and see what's going on and make sure we protect you from them increasing the property tax bill.
Okay, we are
Thank
short
you.
on time today because of a few interferences. So if you let's keep our questions and answers short. So Tina, then Steve, then Cliff, then Douglas.
So my question relates to, you mentioned there's two types of trust, that you have dynasty and spendthrift. What's the difference between both?
Well, the dynasty trust is goes on for generations. Okay.
Fair enough.
So yeah, but all of those provisions, the spendthrift, the dynasty, all of that is the spendthrift is for asset protection. Okay. So all of it is put into our one trust to give you all of that, all the benefits of all of those different parts of the trust. It's non-grantor, irrevocable, complex, discretionary spendthrift trust.
Okay, thank you.
Thank you. Steve.
Well, thank you, Peggy, and thank you, Ruth. That was great presentation. I have a question regarding the irrevocable part of the trust. What are some of the disadvantages of having an irrevocable trust versus a revocable?
Well, basically an irrevocable trust, when you go to an attorney that's doing a living trust, an irrevocable trust is you put your beneficiaries, you set everything, and it's set in stone. You cannot change it. What we mean by irrevocable in this particular trust is when the grantor, which is somebody besides you, sets up the trust, they're going to sign away all their powers and rights. That's the part that's irrevocable. You see what I mean? So it's not where it doesn't mean you can't add and remove beneficiaries, hire, fire trustees. You have full control of the trust.
Thank you. That's a great distinction. Appreciate it. Back to you, Peggy.
Thank you, Steve. Cliff?
Okay, I do have a few questions. How many trusts are normally in this? Okay, so it sounds like that there's a trust and a foundation. Is there also something else, or is that it?
No, well, there's a family holdings trust. So that trust holds all of your assets. It can own your cars, your homes, rental properties, your boat, anything that if somebody were to sue you, anything that you don't want to lose, you put it into the family holdings trust. Then we have a business trust that helps with your tax, your income tax when it comes to the actual business. So we have a business trust and a family holdings trust. And the
And what about the
foundation.
foundation?
The foundation is for tax mitigation, not asset protection. So the trust is asset protection, foundation helps you get rid of those taxes.
Okay, so you have to have the foundation for the tax benefit.
Yes, we will not put out a trust without a foundation with it.
Okay, is that
There's no additional cost to it. It just comes as a package.
so? Is that foundation like a charitable tool?
Yes, it is.
Okay,
And
all right,
you
that
own
makes
it,
sense.
you control it, you can get paid. You could get paid fees for running the foundation. You can get paid trustee fees for your non-grantor trust also.
Okay, how do you manage the handoff of this to multiple heirs? And once it's handed off, how do they manage control?
Well, once you pass away, then typically you have beneficiaries, you have successor trustees. So in my particular trust, my husband and I, we have 7 daughters. So everybody's a beneficiary, but we made 2 of the daughters, one that he birthed, one that I birthed, our successor trustees. So if something happens to us, they now move in and they control the trust. So remember, these are generational trusts. So when your kids, they acquire the properties and no property taxes change, nothing happens because now they become the trustee and they keep using it and they can sell their assets to the trust. They can, they don't have any fee to it. They just take it and run with it.
Okay, yeah, that makes sense. But how do they manage control? So would they have voting rights, or how does that work?
Yes, as the trustee or a trust protector. So the trust protector is like the owner of a business. You have full control. So you need to set up in advance for my case, the 2 kids that I have set up in ours, we told them what we wanted to happen. So they would have control as far as selling the properties, giving money to the beneficiaries. They would have the say because they know what we asked them to do. You know what I mean? So
Okay,
they just take over and keep going with it.
all right. And is this based on statutory law, common law, or something else?
Contract law.
Contract law. Okay, very good. So you're not tied to a specific state. So that would mean with a foundation, there would be no state taxes that would be incurred with. Is that correct?
Right. If your state doesn't
Okay.
have tax, yes, there's no state
Well,
tax.
no, I mean, even if the state had tax, if everything's held in this and you have a
Oh, yeah,
foundation, anything
in the
that would go through the
foundation.
foundation because it's contractual law would not be taxable.
Correct.
Yeah, okay, that makes sense.
The trust will have tax, but the foundation doesn't.
Right,
Mhm.
makes sense. And then for the family holdings and the foundation, what would typically be something someone would be looking to spend for that?
It depends on the needs of the actual client. Typically for the family holdings trust and the foundation, it's $35,000. If they want to add a business trust to it, it's $45,000. Now that's a basic client. We've have some people that have multiple businesses and corporations and LLCs that the attorneys have to deal with. So it could get higher than that. And we also have, we call it a light version of the trust. We call it the estate builder. So these are for people that maybe just own their home and they want asset protection, and that's more about, and that trust comes with the foundation and it's around $10,000.
Very nice. Okay. Can this structure hold a life insurance policy or make premium payments or both?
Absolutely.
Okay. Is the insurance policy held inside of the foundation?
My insurance policy is held by my family holdings trust.
So family holdings trust. All right. And then are you licensed in life insurance also?
No.
Okay. How do I purchase crypto into this with KYC? Because KYC really seems to be a barrier with anything that's not you. How do you get around this?
Well, I'm not that familiar with crypto, but for some companies, we buy it. Mostly everything you want to buy once you own the trust, you buy it in the name of the trust. So we would have to talk to the companies that you want to buy from and see if we can do a workaround, but the attorneys would be willing to talk to them.
Okay.
And
Last question. Can I get a credit card with this?
Absolutely.
Okay. And
You could buy cars. You could do all types of things with it.
Trust
so I
King.
can get a credit card with the trust. Okay. All right. Thank you.
Thank you, Cliff. Great questions. Douglas.
Slightly different. Cliff kind of went there a little bit with my question, but where do you think, Ruth, for the cost benefit analysis of this, what net worth do you think you need to be looking at for folks to talk to you about this product?
I don't think there's a specific net worth. I think especially with the estate builder trust being closer, the 10,000 range, I believe anybody that owns a home needs to have their assets protected. If you're running a business, you need to protect your assets, right? So, it's any range actually, but we do have other strategies that, that we use for tax deferral and that. So like tax deferred cash out, I would say at least 300,000 or more in the sale of the asset. Charitable holdings companies, that's a whole different strategy. That one, I would say you should have about $1 million in gain to make the price work on that. 1031, you could get a 1031 done from us for $500 for anything under 400,000 in price. And once it gets to $1 million, it's $1,000. So it really just depends on the client. So typically I set up a consultation with a client and I hear what they have and hear what they want. And, the main question is what do you want to do with the money? What is your goal? And once I know what the goal is, then I can help structure them with the right strategy to get them there.
That good, Douglas?
Yep, that was definitely what I had in mind. Absolutely. Thank you.
So tax deferred cash out, just so you know, 6.7% of the net sales proceeds before the mortgage is paid off is the fee on that one. But I'll send everything to Peggy. She can send it out to you guys on how all of these work.
Thank you. Steve, do you have another question?
No, I think that was brilliant. I've learned a lot. Thank you so much, Peggy, for this, and Ruth as well. Great questions as well.
Okay, great. Thank you. Jordan.
I just had a quick question. Can you hold multiple LLCs within the trust?
Yes.
Okay, thank you.
That was cool. Okay, and I have a quick question. You brought up this $5,000 that you have to donate in the foundation when you, after you sell that property. Do you have to donate it in the year you receive it, or can you donate it down the line?
You have to donate it within the next year by December 31st of the following year.
Okay, great. Thank you.
Mm-hmm.
Cliff?
Can you talk a little bit more again?
I love you're so curious. So thank you.
Yeah. Can you talk just a little bit
questions.
more on the deferment of tax repayment? Because I'm not as familiar with that.
Are you talking about 30 years from now? Like if you use the trust structure?
Yeah, and
Okay.
deferring the taxes that would be paid in the trust structure for 30 years.
So if you sell your property to your non-grantor trust on an installment contract, interest only for 30 years, then you're just paying on the interest as income over the next 30 years. So what a lot of our clients do, because they know the tax bill is going to come 30 years from now, the whole goal is to use the money and build it to the point where they have a lot more money. Sometimes they say 8 times more money when you use life insurance to pay the tax bill that's going to be due in 30 years. Now, typically the IRS, if you're not here 30 years from now, the IRS is going to want the estate to pay the tax bill. But if the estate doesn't have any money in it, then it becomes a moot issue. And I've had personal experience with my daughters losing their father and the amount of taxes and everything he owed, and not one of them came after any one of my 4 daughters for his taxes.
Okay. All right. That's pretty good.
But Cliff, I didn't answer it completely. Most people are putting 1/4 of the tax bill. So if it's $100,000, 25,000 into a life insurance policy, and that 25,000 will grow in enough money to pay the tax bill 30 years from now.
Okay. switching gears, would this structure still require a need for any type of external entity like an LLC or an S corp?
Not necessarily, but I do have a C Corp and a Wyoming LLC, and I kept those in place because when I'm billing my clients and working, the payroll and all that, I left it with the current LLCs and corporations, but you don't have to. When you use the business trust, there's a management agreement. So the business trust runs everything. So you could get rid of your LLCs and corporations if you want to, but you don't have to. You get to choose.
So if you need to keep those entities in place, do you just make the foundation or the trust a 99% shareholder?
The business trust.
The business trust, do you just make them a 99% shareholder, or do you use the management agreement?
The management agreement.
I see. Okay.
And
All
can
right.
you donate your properties to the foundation? So all its
You-
income is making for the foundation, so you can contribute that to a community of some sort?
Yes, you can if that's your goal. That is something that can be done. But you
So
can't
then
take it
it's-
back.
Not that, but when it sells, all that money
Yeah.
goes into the
Goes to
foundation.
the foundation
tax-free.
tax-free. Yeah,
Okay,
Okay. So the trust by itself only provides the asset protection, and that is all. No tax
Correct.
benefit in the trust. So the foundation manages the tax benefits.
correct.
Okay.
Now there's people out on the internet that are selling a trust that say you buy your trust and you can defer your taxes in perpetuity. That's using IRS code section 643. That does not work. So this using
Why
the
doesn't it work?
foundation, because they're saying that the taxes are deferred in perpetuity because the trust can allocate the income to corpus and it's not taxable. So it's just not a firm strategy in the way to use the trust. So the 643 trust, ours is 642, okay? Both of them provide ironclad asset protection, but the 643 people say you don't need a foundation. You could get rid of your tax bill without it, and it doesn't work. Talk to your tax person. My tax person told me that it doesn't work. Okay, so I had to decant my 643 trust, and I'm now in the 642 trust using the foundation. And I know that if I got an audit, T's are crossed, I's are dotted. I've had it looked at many tax people, tax attorneys, and CPAs.
So if I understand correctly, a 643 doesn't necessarily get rid of taxes. It enables you to 643B. You don't
Allocate to
recognize capital
corpus.
gains. Well,
Yeah.
there's no recognition of capital gains in 643B.
Yeah, but if you talk to tax attorneys in that, people are misunderstanding that code. That part of the code 643. It doesn't mean what people think it means. Okay, so 643 is only talking about allocating the income to the beneficiaries or allocating the income to the trust, but the trust still has a tax bill. But the 643 people are promoting it that it doesn't have a tax bill, and that's false.
Interesting. Yeah, I've seen some Supreme Court judgments that have actually upheld that, but it's interesting what you're saying. I'll look into that a little bit more.
I can send you some information on that. I'll send it
Okay.
to Peggy about the 642 versus 643. We have something written up on that, and you could take a look at it.
that's
Thank you.
great. Thank you. Anything else, anyone? Because we are at the top of the hour. Amazing. We got all the way through and still within the hour.
Yeah, just to say that I would love to see that right up on the 642 versus the 643 as well. If
Absolutely.
here.
And anybody else want to see that? Hand up.
Yes, thank
Yes.
you, Peggy. I
Okay,
would like
Steve,
to see.
Yes, definitely.
Doug, and of course, David
And Kathy.
and Kathy. And is that Douglas? Of course, it's Douglas.
I'd
Mike-
like to see the executive summary as well that she mentioned.
Mm-hmm.
That's awesome.
Okay,
Yeah, thank you, Peggy, for putting this together. This stuff is endlessly fascinating and really, really useful.
thank you. I'm glad to hear that.
Yeah, thank you very
And
much.
Eric wants it too. I know
Yeah,
Eric
thanks.
for it already.
Thanks, Peggy.
I got you on my list, and I'll do my best to send it out to all of you. What we well, I just have Dawn handle it. You know, usually you get the recording right after, not too long after, but I don't know if Dawn has the capacity to go in, and it's got to be edited this time. So we have to clean this up before we send it out. So it might not come out today, it might come out tomorrow. I have to let Dawn know she has to go through this. So she's gonna have to watch the whole thing till we got it cleaned up at 2:30. So like that. Thank you, Ruth, very much for coming on and
Welcome.
working with us and explaining everything to everyone. I think it was really a great presentation. I apologize for people that are not, don't have the great integrity some other people have. And
It
we're kind
happens.
enough to leave the show. So thank you. We hope you will come on again.
Absolutely. I have more strategies to talk to you guys about.
Well, that's great. So I will give you a call back.